All right, we now have the go-ahead to begin the round. So whenever you're ready, you can proceed.
Before we begin,
Just 1 second. Thank you for the go-ahead, bailiff. So now that we have permission to get started, we will call the case of Stevie Rogers versus Drew Mars. My name is Judge Vias. You can address me as such or Your Honor. Scoring judges, please look to the two buttons on the lower left of your screen and remember to keep your audio and your video off unless the bailiff tells you otherwise. You should also have your video set to hide all non-video participants. If you haven't done so, please do so now. So this means that the only people on the screen right now you should be seeing are the advocates, one for each side, and myself. Attorneys, can you please make appearances before the court?
yes, Your Honor. Good afternoon. My name is Fabrice Griosione, and I, along with my co-counsel, Ms. Remington Hill,
Good afternoon, Your Honor.
we represent the plaintiff in today's case, Mr. Stevie Rogers.
Good afternoon.
Good afternoon, Mr. Rogers. Defense, can you please state appearances for the court?
Yes, Your Honor. Good afternoon. My name is Josie Bianchi, and today, along with my co-counsel, Mr. Matthew McCurdy,
Hello, Your Honor.
we
Good afternoon.
represent the defendant in today's case, Mr. Drew Mars.
Good afternoon.
Good afternoon, Mr. Mars.
A few pretrial matters to attend to, Your Honor.
Go ahead.
First, the plaintiff invokes Rule 603, which calls for the constructive swearing in of all witnesses who will be providing testimony.
Granted.
Second, we'd like to invoke Rule 615, which calls for the constructive sequestration of all witnesses, barring a party representative. The plaintiff's party rep.
Will you be designating a party representative?
Yes, Your Honor. The plaintiff's party representative is Mr. Steve Rogers.
Defense, will you be designating a party representative as well?
Yes, Your Honor. Ours will be the defendant, Drew Mars.
Okay, motion granted for 615.
We'd also like to direct your attention to evidentiary ruling 17, which is on the third page of that document you've received. If you'd like to take a moment to get there.
Sure, go ahead and continue.
It states that exhibits 1 through 7 have been pre-admitted and may be used at any time throughout trial.
Okay, defense counsel, are you in agreement with that?
Yes, Your Honor. That's our understanding of the stipulation as well.
Okay.
And lastly, Your Honor, since we've never had the pleasure of appearing in your virtual courtroom before, should we ask for permission before displaying exhibits that have not been entered into evidence, or may we assume that they are constructively outside the view of the jury until they've been admitted?
Ask for permission, please.
Yes, Your Honor. And with that, plaintiff's ready for trial.
Can you pronounce your last name one more time, please, counsel?
Griosione.
Griosione. Thank you. Defense, do you have any pretrial matters to attend to?
No, Your Honor. With that, we're ready to proceed to openings as well.
Okay, so we will now hear opening statements from each party. Everyone should make sure they are in speaker view now, including myself. That button is located in the upper right-hand corner of your screen. Attorneys, please remember to mute your audio when the other attorney is speaking. Whenever you're ready, counsel.
Judge Vias, opposing counsel, members of the jury. I want you to imagine we're in an old mansion out in the woods. A grandmother has just fallen asleep in her bed. When out of the darkness, a man starts tiptoeing down the hallway towards that grandmother's room, holding 2 deadly pills. He slips those pills into the grandmother's pillbox, so when she unknowingly takes them, her heart stops beating and she dies. Members of the jury, that grandmother was Agatha Lee. You can see her here. She's the mystery novelist we all know and love, whose imagination captured the hearts and minds of readers across the country. That man creeping into Miss Lee's room, it was the person who was supposed to take care of her, the defendant in today's case, Drew Mars. you'll hear that the defendant wanted to keep control of Miss Lee's $20 million inheritance. So he used his knowledge as Miss Lee's caretaker to come up with what he thought was the perfect plan. You're going to learn that at the center of that plan were those deadly pills. Because without those pills, the defendant was going to lose the will. Now, you see, in Midlands, if you kill somebody, you can't collect their inheritance, even if you were written into their will. That's why we've brought this lawsuit against the defendant. Now, this is to show you that the defendant is not entitled to Miss Lee's estate. We'll have to show you that she purposefully took Miss Lee's life. Now, this is a civil trial, not a criminal trial, which means that we have to prove that to you by a preponderance of the evidence. That just means more likely than not. To meet that responsibility, we're going to show you that without those pills, he was going to lose the will. Now, I'd like to take a step back and give us a full picture of what happened. We're going to hear from Madeline Bond, a private investigator. She'll tell us that Miss Lee was worth $20 million, but the defendant wasn't. The defendant needed Miss Lee's money. His family back home was struggling to make ends meet, and he had a sibling that was going to die without Miss Lee's money. But for the time being, everything would be okay. Miss Lee had written him into her will, so when she died, he would get the book proceeds, the savings, the $20 million, the house, all of it. All he had to do was wait. That all changed when Mr. Stevie Rogers, Miss Lee's beloved grandson, came into the picture. We'll call Mr. Rogers to the stand, and he'll tell us that Miss Lee began to reconnect with her grandson. He'll tell us that he was away for a few years dealing with the loss of his parents in a car accident. But when he came back to see his Grams, it was just like old times. They played backgammon, they drank tea, they chatted about the latest news. After a few months, Miss Lee realized family comes first. So you'll hear that Miss Lee told Mr. Rogers she was going to change her will. She was going to leave everything to Mr. Rogers. The defendant overheard that conversation and realized he had to act. If Miss Lee changed the will, the defendant and his family would end up broke and his sibling would die. You'll learn that the defendant used his knowledge as Miss Lee's caretaker, specifically that he knew Miss Lee had a deathly allergy to a drug called chloroandramine. It's an over-the-counter drug, you can get it at a pharmacy, but it was deadly to Miss Lee. You'll also hear that as Miss Lee's caretaker, the defendant knew Miss Lee took 2 pills every day that looked identical to chloroandramine in shape, size, and color. So he came up with what he thought was the perfect plan. That very night, you'll hear that the defendant swapped out Miss Lee's daily meds with those deadly pills. Miss Lee would die before she could change her will, and the defendant would get the house, the book proceeds, the $20 million, all of it. Because without those pills, the defendant was going to lose the will. Now, throughout today's trial, members of the jury, I want you to keep 3 questions in mind. First, who knew about the similarities between Miss Lee's daily meds and chloroandramine, that deadly drug, before Miss Lee died? Second, in whose room did the police find chloroandramine? And third, who stood to inherit $20 million if Miss Lee died? Members of the jury, you're going to hear that only the defendant knew Miss Lee would mistake those deadly pills for her daily meds. You're going to hear that only the defendant needed Miss Lee dead, that only the defendant was found in possession of chloroandramine, because only the defendant was going to lose the will without those pills. At the end of today's trial, my colleague, Miss Remington Hill, will stand before you. She'll walk you through the evidence, and she'll tell you that the defendant took Miss Lee's life. She'll ask that you don't let him take your money too. She'll ask you to return a verdict of liable. Thank you.
Thank you, counsel. Defense, are you ready for your opening statement?
Yes, Your Honor.
Whenever you're ready.
It's not a coincidence. It's a setup. A millionaire dies in their sleep. And at the beginning, it appears to be a death from natural causes, but an autopsy report reveals that the real killer is a drug called chloroandramine. A private investigator is hired, and later on, the millionaire's caretaker is arrested and accused of killing her. Sounds like the facts of today's case, right? They are, but they're also something else. They're the plot to a story that the plaintiff, in their opening statement, didn't tell you a single word about. Death in a Bottle. It's Agatha Lee's best-selling novel, and it tells the story of a millionaire who dies in their sleep from chloroandramine. The private investigator is hired, and the millionaire's caretaker is later arrested and accused of killing her. Now, it's not a coincidence that the plot of this story is so similar to the facts of today's case. It's a setup. Good afternoon. My name is Josie Bianchi, and today, along with my co-counsel, I represent Drew Marr. Now, the plaintiff has sued Drew Marr under Midlands Code 20.21. It's what we call the Slayer statute. And the burden to prove that lies solely with them. You heard today that this isn't a criminal trial, it's a civil case. So we won't be talking in terms of guilty or not guilty. We'll be talking in terms of liability. And the plaintiff has to prove each and every element of their case by a preponderance of the evidence in order for Mr. Marr to be found liable. And they won't be able to meet that burden today. Because you'll hear Drew Marr's story, and you'll hear how Stevie Rogers tried to set him up. Now, the plaintiff's opening statement, they told you that their case centered around Drew Marr's monetary motive, knowledge of a chloroandramine allergy, access to Agatha Lee's medications, and a conversation about a will on August 14th between Agatha Lee and Stevie Rogers. Let's break that down. Drew Marr's monetary motive. You'll learn today that Drew Marr wasn't the only person who had been in Agatha Lee's will. Stevie Rogers was in an older version of the will, and he knew that he'd been taken out and replaced with Drew Marr. You'll discover today that Stevie Rogers, well, he also knew about the Slayer statute years before his grandmother died. The Slayer statute's why we're here today. And Stevie Rogers knew that if Mr. Marr was found liable for his grandmother's death, he could inherit everything. Knowledge of Agatha Lee's chloroandramine allergy. Of course, yes, Drew Marr knew of this. He was her caretaker for over a decade while she lived a happy and healthy life. Instead, you'll hear today that Stevie Rogers also knew of this allergy and learned of it 2 weeks before his grandmother died as a result of that same allergy. Access to Agatha Lee's medication. You'll learn today that on August 14th, someone else had access to Agatha Lee's medication, her pills, her pill organizer. Someone else had access to her bedroom. Stevie Rogers had the same access too. And the conversation about the will that happened on August 14th, you'll learn today that that conversation is actually in dispute. We expect Drew Marr to take the stand today, and he'll tell you that he overheard that conversation and he heard something different. You'll also hear from the defense's second witness, Ryan Cabrera. She was Agatha Lee's biographer. And she'll tell you that she met with Miss Lee just an hour after that conversation that's in dispute. And it's there that Agatha Lee corroborated the version of events Mr. Mars heard. Now you might be asking yourselves, how do we know that this is a setup? And that's a great question. You see, the answer lies with Death in a Bottle. You'll learn today that Stevie Rogers was reading Death in a Bottle for the first time in the same month his grandmother was found dead. The police, they found a copy of Death in a Bottle bookmarked inside in Mr. Rogers' room during their investigation into Miss Lee's death. That isn't a coincidence, members of the jury. It's a setup. We as the defense, we ask you to listen throughout the course of today's trial. Listen for who had a monetary motive, for who knew they could inherit $1 million estate. Listen for who had access to Agatha Lee's bedroom, knowledge of a chlorandramine allergy, and for what really happened on August 14th. Because you'll discover today that there's another person who knew everything that Drew Mars did. And that's Stevie Rogers. Why at the end of today's trial, we'll come before you and ask you that you find Mr. Mars not liable for the death of Agatha Lee. Thank you.
Thank you, counsel. Before the plaintiff calls its first witness, I'll ask everyone to switch to gallery view now. And that button is located on the upper right-hand corner of your screen. And this will allow you to see the attorneys and the witness at the same time. Plaintiff, would you like to call your first witness?
Yes, Your Honor. At this time, the plaintiff calls Stevie Rogers to the stand.
Good afternoon, Mr. Rogers. You are presumed to have been sworn in.
Good
Begin
afternoon.
whenever you're ready.
Yes, Your Honor. Could you please introduce yourself to the members of the jury?
Hi, I'm Stevie Rogers.
Mr. Rogers, you're the plaintiff in today's case. So can you tell us why you're suing Drew Mars?
My grandma died 2 years ago. It's Drew's fault.
Can you tell the members of the jury a little bit more about your grandmother?
Sure. Nana was the best. She used to pick me up after school. She'd let me watch Law and Order, even though my parents wouldn't let me because they knew it would give me nightmares. When the episodes gave me nightmares, I mean, Nana was always there. We had the best relationship until I lost my parents.
I'm sorry to hear that, Mr. Rogers. Can you tell us what happened to your parents?
12 years ago, 12 years ago, yes. I lost my parents to a drunk driver. After that happened, I remember thinking to myself, Nana was the only person left in my life. So I tried. I tried to visit every so often, but every time I saw her, I was just reminded of my mom. So I stopped talking to her. I distanced myself. Tried to find a life of my own.
Were you ever able to reconnect with your grandmother?
I was. In May of 2018, Netflix put up Law and Order on their website. I remember seeing it, and I remembered of all the times I missed seeing Nana. So I packed my things. I drove down to Alabama, where she used to live, and I tried to find her. But she wasn't there.
Were you ever able to find your grandmother?
I was. I had to hire someone to help me find her, but we did. We found her right here in Midlands.
When was that, Mr. Rogers?
That was back in July of 2018.
So what'd you do when you found your grandmother in July?
I moved in. I mean, she saw me and welcomed me back in open arms, and I saw how much older she looked, and I realized I had to make up for lost time.
Was your grandmother living alone when you moved in?
No, she was living with Drew Mars, the caretaker.
Can you tell us a little bit more about your relationship with the defendant, Drew Mars?
I mean, at first it was fine. I was grateful that Drew did things that needed to be done in the house.
Things like what, Mr. Rogers?
Like I would see him fill her pill organizer every Saturday.
Your Honor, permission to display what's been previously marked as Exhibit 12 constructively outside the view of the jury.
Does opposing counsel have any objections?
No, Your Honor.
You may display Exhibit 12, you said?
Yes, Your Honor.
All right.
Mr. Rogers, is this the pill bottle, the pill organizer that you were talking about?
Yes, I would see him fill it every Saturday.
Does it look the same as the last time that you saw it?
It does.
Your Honor, at this time, the plaintiff offers Exhibit 12 into evidence.
No objection.
Okay, Exhibit 12 is admitted.
And Your Honor, at this time, let the record reflect that I'll be reading onto the record a portion of the autopsy of Agatha Lee, which is already in evidence as Exhibit 2. Reading from the conclusion, quote, "It is my opinion, to a reasonable degree of medical certainty, that the sole and conclusive cause of subject's death was a fatal allergic reaction to 2 chloroandramine pills." Mr. Rogers, did you know that your grandmother was allergic to chloroandramine?
I did.
How'd you know that?
Drew told me about it.
Mr. Rogers, were you here for all of trial thus far today?
Yes.
And did you hear the attorneys for the defense say that it wasn't a coincidence, it was a setup?
I did hear that.
Is that true, Mr. Rogers?
No, ma'am.
Did you purchase chloroandramine on August 14th of 2018?
No.
Have you ever purchased chloroandramine?
No.
Well, then I want to fast forward to the day before your grandmother was found dead. What day was that?
That was August 14th, that same year.
Can you describe that day for us?
Sure. I remember waking up early that morning, going down to the kitchen to make my grandma's favorite breakfast, and then having it in her study.
Did you and your grandmother speak over breakfast?
We did. We talked about politics, backgammon from the night before, and we talked about her will.
Did you know what was in your grandmother's will when you had that conversation?
Not the details, no. But Grandma said she was planning to change it.
How was she going to do that?
She said she was going to call her lawyers.
Did she tell you why she was going to change her will and call her lawyers?
She said she was happy we reconnected. I mean,
Objection, Your Honor.
I was
Hearsay.
too.
Response? Yes, please.
Yes, Your Honor. The statement that she was happy that they'd reconnected is a statement of a then existing mental state. Under Rule 803.3, that's an exception to the rule against hearsay.
If I may be heard on this grounds, Your Honor.
Yes, you may.
It's one thing to say that his grandmother was happy or sad, but to say why does not fall under the exception 803.3. And to say she was happy because Mr. Rogers came back, because they'd reconnected, that part doesn't meet the threshold for 803.3 and is still hearsay.
Response, Your Honor?
You may.
I don't share in counsel's understanding of Rule 8033. I believe that the entire statement, "I'm happy that we've reconnected," would fall under the exception to the rule against hearsay as a statement of a then existing mental state and is thus admissible.
I'll allow it. Overruled.
Yes, Your Honor. Mr. Rogers, you were talking about your grandmother saying that she was happy that you'd reconnected. Were you finished with your answer?
She said we were happy. She was happy we reconnected, and then she said, I'm grateful you're back to my life again. I mean, I was too.
No. Do you know if the defendant heard your grandmother say that she was changing her will?
I don't know. When I was leaving the room, Drew was standing right outside.
What was Drew doing right outside of the room?
He was glaring at me.
Was the defendant doing anything else besides glaring at you?
His fists were clenched.
Well, did he say anything?
He looked me in the eye and he said, "No way."
Mr. Rogers, now that we know what the defendant said, I want to talk about what he did. So did you see him on the night of August 14th?
I did. I saw him at around 9:35, 9:40 that night of August 14th.
Well, I want to make sure I've got it exactly right. So, Your Honor, let the record reflect. I'll be revealing to the jury an enlarged copy of what's already in evidence as Exhibit 5.
The record shall reflect.
Mr. Rogers, what are we looking at here?
This is a layout of my grandma's second floor. Yeah, that's it.
Well, using the diagram, can you tell us where you saw Drew around 9:40 p.m. on August 14th?
I saw Drew leaving the room, so that's right outside where it says Mars's bedroom.
Your Honor, let the record reflect that my colleague has placed a red dot outside of Mars's bedroom.
Shall reflect.
Mr. Rogers, does that red dot look to be about where you saw the defendant?
Yes, it does.
Now, did you see where the defendant was going?
It looked like he was going towards Grandma's room, so where it says Agatha's bedroom.
Let the record reflect that my colleague has placed an arrow going from the red dot outside of Mars's bedroom towards Agatha's bedroom.
Shall reflect.
Mr. Rogers, does that look to be where the defendant was going?
Yes.
So when you saw the defendant heading towards your grandmother's bedroom, did you see if he was carrying chloroandramine?
I don't know, but I did see him holding something in his hands like that.
Your Honor, let the record reflect that Mr. Rogers is holding up his right hand with his palm up and his fingers closed.
Okay, it will reflect.
So, Mr. Rogers, when you saw the defendant clenching something in their right hand, walking from their bedroom to your grandmother's, did you do anything?
No. I thought it was weird at first, but I didn't do anything at the time.
What about that next morning?
I woke up to Drew pounding on my door, saying Nana wasn't breathing.
So what'd you do?
I ran into her room. I tried to look for a pulse. I tried to see if she was breathing, but there was nothing. She was gone. I had no family left in my life.
Thank you, Mr. Rogers. I'm very sorry for your loss. Nothing further for the witness, Your Honor.
Cross-examination.
Yes.
Go ahead.
Good afternoon, Mr. Rogers. My name is Josie Bianchi, and I'm going to be asking you a few questions today on behalf of Mr. Mars. All right?
Good afternoon, Miss Bianchi.
Let's start by talking about your relationship with your grandmother. It's true that you distanced yourself from her, right?
Yes, every time I saw her face, I was just reminded of my mom. Yes.
After you dropped out of law school in 2011, The next time you saw her in person was 2018, right?
Yes.
Now, for those 7 years, you didn't call your grandmother, right?
No, like I said, I had to distance myself to find myself.
For those 7 years, you didn't have any form of communication with her, right?
No.
Mr. Rogers, let's turn now to your financial situation back in 2018. I'd like to break it down for the members of the jury.
All right.
After your parents passed away in 2008, you gained control of a trust fund, right?
I did.
And that trust fund, it began with $2 million in it, right?
Yes, ma'am.
In June of 2018, that trust fund was down to $2,000. Isn't that right?
That's right.
And you went to go see your grandmother in July of 2018, right?
Yes, that's what happened.
A month after your trust fund was at $2,000?
Yes, but money wasn't the reason I went to visit her. See, I had a BMW, Rolexes that I could have sold. I wanted to see Grandma because I missed her.
I didn't ask you about the reason you went to visit her, Mr. Rogers. I asked if a month after your trust fund was at $2,000, you went to visit her. And the answer to that question is yes, right?
You have that right, yes.
So the first time you saw your grandmother in 7 years was after your trust fund ran out, right?
Yes, when I saw that Law and Order was back on Netflix.
Okay. Well, Mr. Rogers, let's shift gears a bit and talk about what you knew back in August of 2018. In August of 2018, you believed that Drew Mars would inherit your grandmother's estate, right?
That's right.
In August of 2018, you knew what the Slayer statute was, right?
I did.
You sued under the Slayer statute here today.
Yes, ma'am, because it's Drew's fault that Grandma's dead.
So directing you back to my question, you've sued under the Slayer statute today, yes?
Yes.
And in August of 2018, you knew that if Drew Mars was responsible for your grandmother's death, that he would be unable to inherit her estate, right?
That's right.
Okay. And in August of 2018, you also knew of your grandmother's chlorandramine allergy, right?
Yes, Drew told me about it. She kept
That's
talking.
right.
He kept talking about it 2 weeks before.
That's right. 2 weeks before your grandmother died as a result of that allergy, you learned about it for the first time. Is that true?
Yes, he kept talking about it.
Mr. Rogers, you know how to acquire chlorandramine, right?
What do you mean?
Well, I'm asking you, do you know how to acquire chlorandramine?
Drew told me that you could get it over the counter, so I'm assuming that's how you could get it, but I'm not sure.
So to your knowledge, chlorandramine is available for purchase at any pharmacy, right?
I'd assume, yes.
In August of 2018, you also knew of your grandmother's famous book, Death in a Bottle, right?
Yes, it was an inspiration for me.
Mr. McCurdy, would you display what's already in evidence? That's Exhibit 7. You knew that in the story, a millionaire dies as a result of chlorandramine poisoning, right?
Yes, it was inspired by Grandma's allergies. And so now that I write, I take inspiration from my own life too.
I'm not asking you about your inspiration for your new novels, Mr. Rogers. I'm asking you if in this story, a millionaire dies in their sleep from chlorandramine poisoning. And the answer to that question is yes, right?
Yes, ma'am.
The millionaire's caretaker is also charged with murder, right?
That's right.
And it's true that the police found a copy of this book, Death in a Bottle, in your room during their investigation, right?
Objection, Your Honor, to relevance to this book being found in Mr. Rogers' bedroom. We've heard it's been stipulated that 65 million copies of this book are in circulation worldwide. So the police finding one in Mr. Rogers' bedroom is irrelevant. It doesn't make any fact in today's case more or less likely.
Response, Your Honor. While we agree with Ms. Hill that there are numerous copies that have been published all over the world, we actually also know and have an evidence from the police investigation report that the only copy of Death in a Bottle in the entire household was found in Mr. Rogers' room. Furthermore, this is relevant and is probative, as it's central to the defense's theory that Mr. Rogers was reading this book and used it as a sort of template in order to carry out the setup that we've mentioned.
I tend to agree with, excuse me, Ms. Bianchi. Your objection's overruled.
Yes, Your Honor.
So, Mr. Rogers, that's a yes. The police found a copy of Death in a Bottle bookmark inside in your room during their investigation, right?
They did. I wanted to read it to be reminded of Nana's best writing.
All right. Well, we just talked about all of August of 2018. Let's focus now on August 14th specifically.
Sure.
To your knowledge, the only people living in the house on August 14th were yourself, your grandmother, and Drew Mars, right?
That's right.
And for a number of hours on August 14th, you were home alone, right?
An hour or so, yes. Nana was out for lunch.
And while your Nana was out, Drew Mars was also out, correct?
Yes, I believe so.
And to your knowledge, no doors were locked during the mansion at that time, right?
I don't know.
And you knew that your grandmother kept that pill organizer that you were showed earlier today on her bedside table, right?
Yes, I would see Drew change it every Saturday, yes.
And on August 14th, you could access Agatha Lee's bedroom, right?
I don't know, ma'am. I didn't try to open it, so I just don't.
But to the best of your knowledge, there wasn't anything physically preventing you from entering the room, right?
I've heard there's a lock on it, but I don't know.
Okay. Mr. Rogers, let's lastly break down the timeline of events that happened in August a little bit more for the members of the jury.
Sure.
Mr. McCurdy, would you put up a timeline, please? On August 14th, you had a conversation with Agatha Lee about her will, right?
Yes.
On August 15th, you found her dead in her bedroom, right?
I did.
Later that same day, you told 911 you believed Agatha Lee had been murdered.
Yes, I mean she was so healthy the day before, so that was the only reason she could have died.
Mr. Rogers, you're not a healthcare professional, are you?
No, but Nana was glowing the day before.
Okay, so you can't tell us that's the only reason that she died, just to be clear.
I don't know.
Later that day, on August 15th, you told the police that you believe she'd been murdered, right?
Yes.
Let's fast forward 5 days to August 20th. That's the day when Miss Lee's will was read, right?
That was.
You were there?
I was.
Later that same day, August 20th, you filed a lawsuit against Drew Mars, right?
Yes, ma'am.
You're accusing Drew Mars of killing your grandmother with chlorandramine?
Yes, because he did.
Well, it's true that you didn't receive the autopsy report for your grandmother until August 21st, right?
That's right.
And you didn't receive a toxicology screening until August 22nd.
Yes, ma'am.
And those two documents, well, they confirmed that your grandmother died from chlorandramine, right?
Yes.
And Mr. Rogers, on August 23rd, the police found that copy of Death in a Bottle in your room, right?
Yes.
Thank you for your time, Mr. Rogers. No further questions, Your Honor.
A brief redirect, Your Honor, and if Mr. McCurdy could actually redisplay that timeline with just the first two bubbles dating August 14th and August 15th.
All right. Mr. McCurdy, if you may. Go ahead.
Mr. McCarty, if you could go to just the slide with August 14th and 15th, Agatha Lee found dead in her room. Rogers and Lee speak in the study about Lee's will.
Okay.
Thank you, Mr. McCarty.
Whenever you're ready, Ms. Hill.
Yes, Your Honor. Mr. Rogers, on August 14th, when you spoke to your grandmother about her will, what did she tell you she was going to do, if anything?
She said she was going to change it.
And what was she going to change it to do?
She said she was going to leave her estate to me.
And Mr. Rogers, did anyone else hear that conversation?
I don't know, but
Objection,
Drew
Your
was
Honor.
standing outside.
Speculation.
Response, Your Honor?
Response? Yes.
Mr. Rogers doesn't know, he can say so. And I believe when he got to the beginning of his answer, he did say, I'm not sure, but.
I agree. I think he's testifying based on his observation. Overruled.
Yes, Your Honor. So, Mr. Rogers, do you know if anyone overheard that conversation?
I don't know, but Drew was standing outside glaring at me with his hands clenched and telling me no way.
Thank you, Mr. Rogers. Nothing further for the witness, Your Honor.
No recross-examination.
Right. Mr. Rogers, your excuse. Thank you for your testimony today.
Thank you.
Will plaintiff be calling another witness?
Yes, Your Honor. Plaintiff calls Madeline Bond to the stand.
Good afternoon, Ms. Bond. You are presumed to have been sworn in already. Whenever you're ready.
Yes, Your Honor. Good afternoon. Could you please introduce yourself to the members of the jury?
Hi, my name is Madeline Bond.
What do you do for a living, Ms. Bond?
I'm a private investigator and consulting detective. Think Sherlock Holmes, but without the British accent.
Can you tell us about your experience as a private investigator?
Sure. So I actually got into it in college. I played a detective on my college mock trial team, and I loved it so much that after I graduated, I went on to get licensed as a private investigator in Midlands. Over the past decade, I've solved countless cases. You might have even read about some of them in the news.
And what's your connection to today's case?
I was retained by Stevie Rogers to investigate the death of his grandmother, Agatha Lee, the famous mystery novelist and millionaire.
Now, in the interest of full disclosure, are you being compensated today?
Yes, I'm being compensated my standard rate for my work in this case.
Okay, I want to talk about how you got involved in today's case. When did Mr. Rogers first retain you to investigate his grandmother's death?
That was August 15th, 2018.
Your Honor, let the record reflect that Ms. Hill is displaying a timeline of events to the members of the jury constructively outside the view of Ms. Bond.
Having a little bit of technical difficulty, just a moment, mister.
We can move on for now, Your Honor.
Okay.
Ms. Bond, have you ever been to Miss Lee's manor?
Yes, I have. I went for the first time in August of 2018.
Why did you go in August?
Well, on the morning of August 15th, Stevie Rogers called me and told me that his grandmother had passed away. I immediately went to the house to investigate what had happened.
What did you do when you got there?
I went up to the second floor bedroom. That's where I saw Agatha Lee in her bed.
Was there anyone else in that room?
Yes, there was. Stevie Rogers and Ms. Lee's live-in full-time caretaker, Drew Mars, were both present.
What happened to when you got to that second floor bedroom?
Shortly after I arrived, the detective got to the scene and we began our investigations. I learned that on the night that Miss Lee died, August 14th, the only people in the house were Agatha Lee, Stevie Rogers, and Drew Mars.
Okay, let's walk through your investigation into the death of Mr. Rogers' grandmother. How did you begin?
First, I had to figure out what the cause of death was. You see, there weren't any physical signs of trauma, so naturally an autopsy was necessary in order to figure out how Miss Lee had died. After I sent the body over to the medical examiners, I took the opportunity to speak with everyone in the house, starting with Drew Mars.
What did you learn from that conversation with Drew Mars?
Well, since Drew Mars was Miss Lee's caretaker, I asked about Miss Lee's health. I learned that she took a number of medications regularly, including one for arthritis. And then Miss Mars also mentioned to me that Miss Lee had a fatal allergy to an over-the-counter drug called chloroandramine.
So what did you do next with that conversation with Mr. Mars?
I asked Mr. Mars if I could look around his room.
How did he respond?
He refused to cooperate.
What do you mean?
He wouldn't let me look around his room. At that point, I hadn't yet obtained a warrant, so there was really not much more I could do. I left for the day.
And did you ever go back to Miss Lee's residence after that day?
Yes, we were called back to the house to hear the reading of the will on August 20th.
Permission to display what has been previously marked as Exhibit 9 constructively outside the view of the jury?
You may.
What are we looking at here, Ms. Bond?
This is Ms. Lee's will, dated 2018.
Is this a fair and accurate copy as you best remember it?
Yes, it is.
At this time, Your Honor, plaintiff moves Exhibit 9 into evidence.
Are there any objections?
No objection, Your Honor.
Okay, Exhibit 9 will be admitted.
Yes, Your Honor. What happened at the reading of this will?
The lawyer announced that Miss Lee had left her entire estate to Drew Mars.
How did Mr. Mars respond when he heard that?
He acted shocked. He kept repeating, "I can't believe this. I had no idea," which I found to be a little suspicious.
Why did you find that suspicious?
Because I knew it was a lie.
How did you know what the defendant said was a lie?
Objection, Your Honor, speculation. May I be heard? Your Honor, for this witness to say that Drew Mars was, quote, telling a lie, requires her to testify to the intent of my client, as telling a lie would imply some level of an intent to deceive. She can't make that statement without calling into question my client's state of mind.
Response, Your Honor? I believe you're muted, Your Honor.
Had to happen at some point, right? I'll allow for plaintiff counsel to lay some foundation, but if they aren't able to establish how this witness can accurately state that what was said or what was known was false, then please, Mr. McCurdy, make that objection again.
Yes, Your Honor.
So I will temporarily overrule that objection.
Ms. Bond, how did you know what the defendant said was a lie?
Because of an email I found on Drew Mars' computer on August 15th.
Permission to display what's been previously marked as Exhibit 13 constructively outside the view of the jury?
You may.
What are we looking at here, Ms. Bond?
This is that email I found on Drew Mars' computer.
Does this photograph fairly and accurately represent that email?
Yes, it does.
At this time, plaintiff moves Exhibit 13 into evidence.
Any objections?
None, Your Honor.
Okay, Exhibit 13 is admitted.
Why was this email significant in determining that the defendant had lied?
Well, in this email, Drew Mars wrote that Agatha Lee had just changed her will and that she was leaving everything to Drew Mars.
When is this email dated?
February 1st, 2018.
And when was the reading of the will?
That was August 20th of that same year. In other words, Drew Mars had known about this will for 7 months.
Okay, Ms. Bond. And what happened after you discovered the defendant had lied?
The state's detective agreed to order that autopsy and toxicology report after all.
Your Honor, the defense would renew the objection. May I be heard?
Okay, yes, I'll hear argument on this objection.
Your Honor, it's one thing for this witness to say it was what the email said was inconsistent with what she heard on August 20th at the reading of the will. It's entirely different for her to say our client lied. That's something that only our client can testify to. That's something only our client can say whether or not, or what he was thinking at the time he made either statement. This witness can't go that far.
Response, Your Honor?
Yes.
We've absolutely laid the proper foundation that what the defendant said was a lie. We've shown that the defendant said one thing. They didn't know about the will on August 20th. We've also shown that the defendant clearly knew about this will and expressed that in his own words 7 months prior. That's the definition of a lie, and this witness can testify to that.
Response, Your Honor.
You may.
Again, for a lie to be established, there has to be some intent here. An intent has to be shown that the person who made this statement was intending to deceive or mislead other people. Miss Bond, with her experience investigating, cannot talk about whether or not my client intended to mislead anyone. She can say it was inconsistent with what she found, but to make the leap to a lie to establish intent on behalf of my client is speculation.
Response, Your Honor.
No, I think that the characterization of calling it a lie versus an inconsistent statement just goes a little far. So I will sustain the objection, and we will remove the references to that statement as being a lie from the record constructively,
Yes,
of course.
Should we constructively replace those instances of lie with inconsistency?
Please do.
Yes, Your Honor.
Go ahead.
So, Ms. Bond, what happened after you discovered the defendant's inconsistent statements?
Well, the state's detective agreed to order that autopsy and toxicology report after all.
Did you get the results of those reports?
I did, yes.
Ms. Hill, if you could please pull up Exhibit 2, which has been pre-admitted into evidence. What are we looking at here, Ms. Bond?
This is that autopsy report.
What did this report tell you about how Miss Lee died?
So the state's medical examiner concluded to a reasonable degree of medical certainty that Miss Lee died due to a fatal allergic reaction to chloroandramine. And that's the same drug that Mr. Mars, had mentioned to me earlier. So at that point, it became my job to figure out how Miss Lee had ingested this drug that she was fatally allergic to.
How did you go about doing that?
So I looked at the medications that she took regularly to see if there were any clues as to how that drug made it into her pill organizer.
And what did you find?
I found that she took an arthritis medication regularly, and that this medication was identical in shape, size, and color to chloroandramine. So it was possible that someone had switched these pills without Miss Lee realizing.
Ms. Bond, where can somebody purchase chloroandramine?
It's regularly sold over the counter at most pharmacies. So I guess anyone who went to a pharmacy could purchase it. That's why I asked everyone in the house if they had been to any pharmacies recently.
And did you find any of the people in the house had been to a pharmacy recently?
Yes, Drew Mars.
What stood out to you about the fact that Drew Mars had been to a pharmacy recently?
Well, Mr. Mars was Miss Lee's caretaker, so he had immediate access to her medication.
Did you ever find chloroandramine in the defendant's possession?
Yes, I did. After the police obtained a warrant, we conducted a search of Drew Mars' room on August 21st. We found a bottle of chloroandramine pills in a black bag in his closet.
Ms. Bond, do you recognize this photograph? Excuse me, Your Honor. Permission to display Exhibit 15 constructively outside the view of the jury?
You may.
Ms. Bond, do you recognize this photograph?
I do, yes, that's the bag we found.
Does it accurately represent the bag as you last saw it?
Yes, it does.
At this time, plaintiff moves Exhibit 15 into evidence.
Are there any objections?
No objection, Your Honor.
Okay, Exhibit 15 is admitted.
Aside from being found in the defendant's closet, was there anything else to tie this bag to him?
Yes. The police conducted a fingerprint analysis and we found a partial print on the zipper, right where that red circle is.
Who did that partial print belong to?
Drew Mars. It was a 16-point match.
Ms. Bond, during the course of your investigation, did you find the drug that killed Miss Lee in anyone else's possession?
No, only Drew Mars.
Do you know if anyone else gave you contradictory statements?
No, as far as I know, just Drew Mars.
Ms. Bond, did anyone else stand to inherit $20 million as a result of Miss Lee's death?
No, the only person named in the will was Drew Mars.
Thank you, Ms. Bond. No further questions, Your Honor.
McCurdy, whenever you're ready.
Miss Bond, I want to start by talking to you about how you got involved in this case in particular, okay?
Sure.
Now, in August of 2018, the plaintiff hired you to investigate Miss Lee's death.
That's right.
And obviously, you're going to get paid for that work, right?
Yes, this is my job.
Now, I want to turn your attention to the phone call that morning that the plaintiff gave you.
Sure.
The plaintiff mentioned that Miss Lee had died, correct?
Yes, he told me that she had died.
Specifically, Mr. Rogers said she had been, quote, murdered. Isn't that right?
Yes, that's what Stevie Rogers said. Of course, I had to do a full investigation before I could actually make a conclusion about what caused Miss Lee's death.
So you decided you were going to go to Lee Manor that morning, correct?
Yes, I did.
And you got there around 9:25.
Yes.
And about 5 minutes later, a detective showed up.
Yes, Detective Collin.
So to be clear, before you got there, to the best of your knowledge, no police had been on the premises.
As far as I was aware, no. The police showed up about 5 minutes after I did.
And I want to turn your attention to 10 o'clock that morning. The four of you, and by the four, I mean yourself, the plaintiff, Drew Mars, and the detective gathered in Miss Lee's study. Isn't that right?
Yes, we did.
And while you were in that study, you talked about what to do with Miss Lee's body.
Yes, we did. Drew Mars was pretty insistent about cremating the body, but I was concerned that that would destroy evidence. So we had the body held until we could decide whether an autopsy was necessary.
Well, I want to focus on that conversation, and I want to turn your attention to what Mr. Rogers was saying then.
Sure.
You'd agree that Mr. Rogers was demanding an autopsy, right?
Yes, Stevie Rogers wanted an autopsy.
Mr. Rogers was also asking for a talk screen, correct?
Yes, that would be part of the autopsy.
And to be clear, he was the only one making those requests.
I'm sorry, I think I missed a bit. Could you repeat your question, please?
Yes. To be clear, Mr. Rogers was the only one making those requests, right?
Yes, it was just Stevie Rogers and Drew Mars and the detective in the room. Drew
Now,
Mars wanted the body to be cremated, and Stevie Rogers wanted an autopsy.
Now, also during that morning, you pulled Drew Mars to the side to ask questions, right?
Yes, of course. I spoke with everyone in the house.
And you mentioned that you asked Drew Mars to search his room.
Yes, I asked Drew Mars to search his room as part of my investigation into the house in general.
And Drew Mars said no, correct?
Yes, Drew Mars refused to cooperate with the investigation.
You never asked to search the plaintiff's room that day, did you?
No, the plaintiff volunteered the house and the room to be searched, so I didn't need to go out of my way to ask him.
So the answer to my question is no, you did not ask.
No, I didn't.
But you also said on direct examination, I wrote it down, that after Drew Mars, quote, refused to cooperate, you, quote, left for the day, right?
That's right. We hadn't yet obtained a warrant, so we couldn't force Drew Mars to let us search his room. We actually ended up coming back a week later to do the search after we got the warrant.
Ms. Bond, that didn't stop you though, did it?
What do you mean?
Well, on August 15th, you searched Drew Mars's room anyway, didn't you?
I'll admit, when Drew Mars was speaking with the police, I took the opportunity to go take a look inside his room. That's how I got that email I mentioned earlier.
So when you said you left for the day after Drew Mars told you you couldn't search his room, you weren't entirely truthful, were you?
No, I was telling the truth. I left for the day just a little bit after I searched Drew Mars' room.
Now I want to talk about that search. You were alone in that room, correct?
Yes, I was.
The police officer, despite being on the property, was not with you.
No, she was speaking to Drew Mars.
Nobody there was to see what you were doing.
I
Objection, Your Honor.
suppose not.
The question calls for speculation. To say that not a single person saw what Miss Bond was doing is to speculate in the mindset of other people. She can testify to what she knows if she saw somebody looking at her, but to say nobody saw her, that's asking for speculation.
Response, Your Honor.
Go ahead.
This witness has already testified that she was alone in my client's room during the search. It's within her rationally based perception to say whether or not anybody there was able to see her searching that room.
Response, Your Honor.
Sure.
Well, that's exactly our point. She's already testified that nobody else was in the room, and that's what she can testify to. She can't take it a step further to say nobody saw her.
Last word, Mr. McCurdy.
Yes, Your Honor, it's rationally based perception. This witness can see with her own eyes. She can see if anybody else was in the room. She testified that nobody else was there. She can say whether or not anybody else saw her. If Mr. Guillot CNA would like me to rephrase the question, I can.
I don't think that's necessary. Overruled.
Yes, Your Honor.
So, Miss Bond, while you were in that room alone, nobody saw what you were doing.
I can't be sure, but no one to my knowledge.
And that's when you found that email, correct?
Yes, it was on Drew Mars' computer, sent from his email address.
To be clear, when you were searching that room, you didn't have gloves, did you?
No, I didn't have gloves.
And we're going to come back to this search in a little bit, Miss Bond. But I want to turn your attention to about 6 days later, August 21st.
Okay.
That's the day you got the autopsy report, right?
Yes, that's right.
Showing what's been previously admitted as Exhibit 2, Your Honor. This is that same autopsy report, isn't it?
Yes, it is.
And you'd agree with me that the medical examiner determined here that the sole and conclusive cause of Miss Lee's death was a fatal allergic reaction to chlorantramine, right?
Yes, exactly.
And you'd also agree with me that the date of this autopsy is August 21st, correct?
Yes, that's the day we got the report back.
And so after you got this report, you headed back to Lee Manor.
Yes, I did. We had obtained a warrant because of this autopsy showing that Miss Lee had ingested this deadly drug.
Now I want to focus on this search this time.
Sure.
You found yourself back in Drew Mars's room for the second time, correct?
Yes. So it was at that point when Drew Mars became a suspect. Because Ms. Lee had died as a result of ingesting this fatal medication, and we knew that Drew Mars was the person who managed her medications. Drew Mars had also been the person to tell me about the allergy, so we were certain that he was aware of it.
Ms. Bond, all of my questions can be answered with a yes or no, and I'll ask you one more time. It was very specific. During the search of August 21st, you found yourself in Drew Mars's room for the second time, right?
Yes, that's right.
And it's during that search when you found that black bag with that bottle of pills you talked about on direct examination, correct?
Right, in Drew's closet.
Now, you also mentioned that you found a fingerprint on that zipper, right?
Yes, I did.
I want to be clear, Miss Bond, it's a fingerprint, correct? Singular?
That's right. There were other smudges that indicate there had previously been fingerprints, but they weren't actually matchable to an identifiable individual.
Right. And you had just been in that room a few days prior without gloves, correct?
Right. But see, I found the fingerprint on the black bag. I hadn't found that bag or touched that bag previously. So the fingerprints would not have belonged to me, if
Ms.
that's
Bond,
disgusting.
again, my question was very specific. Yes or no, you were in Drew Mars's room just a few days prior without gloves.
Yes, but the only thing I touched was Drew Mars' computer.
I want to go back to this one fingerprint on the zipper. You'd agree it's unusual to use one finger to open a zipper, right?
So the thing is, with fingerprint analysis, It doesn't actually mean that.
Your Honor, I have to object to non-responsive.
Response, Your Honor.
Go ahead with your response.
Opposing counsel, Mr. McClody, has just asked my witness a hypothetical situation. She's an expert in this field. She should certainly be able to explain her answer instead of just giving a yes or no.
May I respond, Your Honor?
Sure.
Your Honor, pursuant to Rule 702, opposing counsel has not laid any foundation for this witness to be an expert in any field, let alone fingerprint analysis. Secondly, and more to the point of my objection, non-responsive, this witness has gone on to how to do fingerprint analysis, which, to Mr. Guillocine's point, would require an expert opinion. I didn't ask her how fingerprint analysis was done. I asked her if you could open a zipper with one finger.
Your Honor.
Okay, so there are two objections here to be addressed. As far as non-responsive, the question did call for a little room to explain a little bit, at least as far as her personal opinion, whether expert or not. Now, we need to address the lack of foundation for expert testimony objection. So please respond to that.
Yes, Your Honor. My apologies. We have not qualified the detective as an expert under the rules of Midlands. I was simply trying to say that she has expertise in this field, and she's just using that expertise, not in the legal sense, but rather her experience in the field to explain her answer to what opposing counsel is asking.
Okay, so Ms. Bond is not being offered into in this trial as an expert witness then?
Yes, Your Honor.
Okay, Mr. McCurdy, do you accept opposing counsel's explanation there?
Yes, Your Honor. It's for that reason that this witness, then at this point, cannot make the statement she's about to make about how to do a fingerprint analysis and what would be left behind as a result of that analysis. That would require an expert.
Okay, so I will sustain under the condition that the witness not answer this question going into deep expertise for fingerprint analysis, since she has not been established as an expert in that field. But I will allow for some room for the witness to answer more than just a yes or no on this question. Sustained under that reasoning, please continue.
Yes, Your Honor.
Now, Ms. Bond, in your experience, it would take a minimum of 2 fingers to pull a zipper open, correct?
I suppose so. I certainly can't open a zipper with one finger. But the thing with the fingerprint analysis is that just because there's only one usable fingerprint doesn't mean that there weren't more fingerprints. In fact, we did find smudges. We just couldn't tell you who they belonged to.
So I want to turn your attention now to the evidence you claim to have against Drew Mars. Your Honor, my co-counsel will be displaying a demonstrative. We've shown it to opposing counsel before today's trial. Ms. Bond, you talk a lot about who knew of Miss Lee's chlorantranine allergy, right?
Yes.
And you say that Drew Mars had that knowledge?
Yes, Drew Mars is the person who told me about this allergy.
It's also true the plaintiff had that same knowledge, correct?
That I can't be quite certain of.
No. Well, Ms. Bond, you did interview everybody, like you said, right?
Yes, I did.
And you are familiar with Exhibit 6, the police report, correct?
Yes.
And you're familiar that Detective Khan put in that police report that the plaintiff had that knowledge?
Oh, yes. So I didn't directly interview Stevie Rogers about that specific question, but the detective did. So yes, I suppose you could say that Stevie Rogers has that knowledge.
I want to turn your attention now to who had access to Miss Lee's pills on August 14th. You said that Drew Mars had access, correct?
I believe so, yes. Drew Mars managed Miss Lee's medications.
And to the best of your knowledge, the plaintiff could have had the same access, right?
I suppose so. I wasn't at the house, so I'm not sure exactly what happened on the day in question. I just know that Drew Mars said he filled the pill organizer every week.
So Ms. Bond, you just said you suppose the plaintiff had the same access. That would be a yes to my question, right?
I can't be sure, but I suppose so.
Thank you.
Objection, Your Honor, to attorney testifying.
May I respond, Your Honor? I believe you're on mute, Your Honor.
Dang it. Okay, hopefully that's the last time that happens. Can you repeat your question, please, Mr. McCurdy?
Yes, Your Honor. I said, Ms. Bond, you just said you suppose the plaintiff could have had access to Miss Lee's pills on August 14th. That would be a yes to my question. The original question was, to the best of your knowledge, the plaintiff could have had access to Miss Lee's pills on August 14th.
If I could clarify, Your Honor, I'm not objecting to the question.
Okay, explain then.
I'm objecting to the markings on this demonstrative that Mr. McClurdy is using.
Okay, response to that, Mr. McCurdy.
Yes, Your Honor. Again, this just reflects what this witness is testifying to. He said it's a possibility. This reflects all the possibilities that this witness has testified to through her direct and the cross-examination at this point. We're not saying that this is definitive. This testimony and other evidence to support it is going to be elicited throughout today's trial.
Response, Your Honor.
Yes, how is this inconsistent with what's being testified to right now?
What Ms. Bond testified to was that she doesn't know whether the plaintiff had access to Miss Lee's pills on August 14th. So for Mr. McClurdy to put a check mark indicating definitively that the plaintiff did have access to Miss Lee's pills on August 14th, that's Mr. McClurdy's testimony, not Ms. Bond's.
May I respond, Your Honor?
Yes, last word.
Again, it's consistent with what this witness just said. Mr. Guillacine has left out the part where this witness said, I suppose that the plaintiff did have access, but I wasn't there. The next follow-up question was, when I asked you if the plaintiff could have had access, you said you suppose that they did. The answer to my question would be a yes. This witness is in agreement. This is a fair comment on her testimony.
I'm sorry, Your Honor, but opposing counsel is actually mischaracterizing what Ms. Bond said. She said she supposed it was a possibility.
Okay. I'm sorry. I said the last word was to Mr. McCurdy. Thank you for what you offered. But I do understand the plaintiff's argument here. It seemed like the first check mark was a more definitive yes, as opposed to the second check mark where she said, I suppose, not a definitive yes. So what are you offering these check marks to mean? A yes or a perhaps or what?
At this point in the trial, Your Honor, this is just a perhaps. Like I said, the defense will be presenting its own evidence that in closing arguments will establish all of these.
I will let you, yes, I'll let you respond.
In that case, I'd like to shift my objection to misleading the jury under Midland's Rules of Evidence 403. A check mark doesn't say it's possible. A check mark says definitively this is true. So Mr. McClurdy's putting up there a check mark to say absolutely the plaintiff had access to Miss Lee's pills on August 14th, and that's not what Ms. Bond said.
Response, Your Honor, under 403 then.
Yes, response to that objection, please.
For relevant evidence to be excluded, any of those reasons prescribed under the rule has to substantially outweigh its probative value. Mr. Guillocina's argument does not rise to the substantially high bar to exclude relevant evidence.
Response.
Okay, I think I've heard enough. Thank you to both of you. So I will allow the demonstrative to continue under the understanding, and this will be told to the jury, that these check marks, as you've conceded, Mr. McCurdy, they're not definitive yeses. They're perhaps, they're maybes, and the jury will have that understanding made clear to them so as to avoid confusion. So I will allow the demonstrative to continue. Overruled.
Yes, Your Honor.
Now, Ms. Bond, you had access to Drew Mars's room, correct?
Yes, on August 15th.
There was nothing preventing you from going into that room, right?
Not on August 15th. His door was left open.
To the best of your knowledge, the plaintiff could have that same access, right?
I guess it depends when you're talking about. I'm not sure if Drew Mars' room had a lock or not.
Well, to the best of your knowledge, I'm not giving you any specific data. Again, we're talking in possibilities here. The plaintiff could have had that same access, right?
I guess it's possible.
I want to talk about who had access to Miss Lee's room. You said Drew Mars had access, right?
Yes, Drew Mars was regularly in Miss Lee's room as part of his job, excuse me.
To the best of your knowledge, the plaintiff could have that same access, correct?
I can't be sure, but I suppose it's a possibility.
And you also were present, again, on August 21st when the detective searched the plaintiff's room for the first time, right?
Yes, I was.
And they found one copy of Death in a Bottle.
Yes, they did, on the bedside table.
That was in the plaintiff's room, correct?
Yes, it was.
And you mentioned, or I want to talk about a possible motive here. It's your contention that Drew Mars could have killed Miss Lee to prevent the will being changed, right?
Drew Mars, yes.
But you also acknowledge that it's possible the plaintiff could have had motive.
I didn't actually find evidence of a motive.
Ms. Bond, I wasn't asking you what evidence you found because we know you didn't search the plaintiff's room, but you do acknowledge the possibility that the plaintiff could have motive in this case.
So I wouldn't have found a motive by searching Mr. Rogers' room. I would have found a motive by speaking to him and Drew Mars and the other people at the scene.
Is it your testimony today that you don't acknowledge that possibility?
Oh, yes, it's a possibility. Everything's a possibility. I just didn't find any evidence.
Thank you, Ms. Bond. No further questions at this time, Your Honor.
There be a redirect?
Yeah, brief redirect, Your Honor. Just a moment to set up. Okay, just a moment. Okay, Your Honor. Are you proceeding?
Go ahead.
Ms. Bond, Mr. Baclutius got up here and asked you about some possibilities. I want to clarify for the members of the jury what you know and what you can say and what you can't say. So, first of all, to the motive. What evidence did you find for a motive for Mr. Rogers?
I didn't find any evidence that Mr. Rogers had a motive.
How about that Mr. Rogers had read this book, The Sole Copy of Death in a Bottle?
So there was a book on his bedside table, but that certainly wasn't the sole copy. It's a best-selling novel. There's 65 million copies in circulation.
Was the plaintiff the only person who could have had access to Miss Lee's room?
No.
Was the plaintiff the only person who could have had access to Drew Mars' room?
No.
Was the plaintiff the only person who could have had access to Miss Lee's pills on August 14th?
No.
Was the plaintiff the only person with knowledge of that chlororangimine allergy?
No.
Your Honor, at this time, let the record reflect that plaintiff has been crossed out with a red line
The record shall reflect.
and replaced with defendant.
It shall reflect.
Ms. Bond, did you find that the defendant had knowledge of a chlororangimine allergy?
Yes.
Did you find the defendant had access to Miss Lee's pills on August 14th?
Yes, I did.
Did you find that the defendant had access to his own room?
Yes, he did.
Did you find evidence that the defendant had access to Miss Lee's room?
Yes.
And finally, did you find evidence that the defendant had a motive to kill Miss Lee?
Yes, I did.
Thank you, Ms. Bond. No further questions, Your Honor.
Will there be a recross?
No recross, Your Honor.
Okay, Ms. Bond, you are excused. Thank you for your testimony today.
Thank you.
Did you have something to say, Mr. McCurdy?
I think my co-counsel is going to address the point, Your Honor.
Okay.
It can be either of us, sorry. We just wanted to ask the court's opinion as to taking a pause in between the two cases in chief because we're running slightly long, given that we've only done half of the trial for all loss. I don't know what your preference is, my opponents, scores, and Judge Vias, but we'd be happy foregoing the 10-minute break in between to continue on.
Okay, would everybody be okay with just a quick 2-minute break, or is that going to put us at risk here?
Your Honor, I think for the plaintiff, sorry, go ahead.
No, go ahead. What is your opinion on that?
for like a 2 to 3 minute break, I think that'd be ideal.
Okay, bailiff, I will defer to you here.
I think a 2 to 3 minute break is fine, Your Honor.
Okay, let's do 3 minutes just because I know that I would like a quick break. And I will at this time remind everybody, just a friendly reminder that this is being publicly broadcasted on YouTube via live stream. So keep that in mind, and we will reconvene in 3 minutes at about 1:14. Thank you.
For the competitors, I'm going to go ahead and put you into breakout rooms. This will obviously be pretty brief, and I will summon you back when it's time to begin the trial. At this point, these students have now had 2 minutes to have their break. Judges, I need to confirm that you're all still back and in attendance. If you wouldn't mind, please just turning on your videos so that I can see and confirm that you're here. I'll be able to then close the rooms and bring the students back in. Okay, I'm just waiting on a couple more here. Great, and then Lauren, are you here as well? I think we're just waiting on Lauren at this point, and we do need to wait to make sure that she's able to come back before we proceed.
I'm back. Sorry about that.
No problem at all. All right, I'm going to go ahead and close the rooms, and then once I'll let you know once all the students are back and when we can proceed. All right, Your Honor, at this point, everyone is present and we should be ready to proceed.
Okay, thank you, bailiff. And just for purposes of the record, has the plaintiff rested their case in chief?
Yes, Your Honor, plaintiff rests its case in chief.
Okay, we will move on to the defense's case in chief. Defense, please call your first witness.
Yes, Your Honor. The defense calls Drew Mars.
Okay, good afternoon, Mr. Mars. You have presumed to have been sworn in already.
Yes.
Good afternoon. Could you please introduce yourself to the members of the jury?
My name is Andrew Mars.
What do you do for a living?
I'm a registered nurse. I usually do physical therapy or recovery work, end-of-life care. More recently, though, I've started volunteering at some local urgent care centers.
Mr. Mars, you've been here throughout the course of today's trial thus far. I have to ask you, did you kill Agatha Lee?
No. No, of course not. I was her caretaker for a decade. We were like family. No, of course.
Let's start by talking about Stevie Rogers. Do you know who that is?
Yes, Stevie is Agatha's grandson, her only one.
When did you first meet Mr. Rogers?
When I began working for Agatha, so back in 2008.
Did you see Mr. Rogers often?
Yes. No, Stevie would come stay with us during the summers, and back then, I mean, he would call Agatha almost every day.
You said back then Mr. Rogers would call almost every day. Did that ever change?
Yes, when Stevie's mother died, Veronica. That death was incredibly hard on Agatha. She couldn't sleep, eat, she didn't function. And at the same time, I mean, I stopped seeing Stevie come visit.
From July 4th of 2008 to July 4th of 2018, how many times did you see Mr. Rogers?
Maybe two. I really can't remember. Not since we moved to Midlands, which was back in 2011.
Okay. Mr. Mars, let's talk about one day in particular, August 14th. We've heard a lot about that date today. Can you tell us how that morning began for you?
It began a bit differently. You see, normally I make breakfast for Agatha, but that day Stevie did. The two were talking in her study all morning.
Did you hear what they were talking about?
Yes. Around 11 or so, I went upstairs. I was standing outside to the door to the study when I overheard them.
Mr. McCurdy, would you display what's already been entered as Exhibit 5? It's a map of the second floor of the Lee Manor. Mr. Mars, where were you standing when you overheard this conversation?
In the sitting area, outside the doors to Agatha's study. Stevie and Agatha were inside the study.
Let the record reflect that we're placing a red dot outside the doors to the study. Mr. Mars, is this correct? Is that where you were?
Yes.
What did you hear them talking about?
Stevie asked whether Agatha would include him back in the will, since he'd shown how devoted a grandson he had been.
How did Miss Lee respond when Mr. Rogers asked about the will?
She said she loved Stevie, but loved having him around, but that she wouldn't be changing her will. She wanted Stevie to stand on her own 2 feet.
What happened after you overheard that conversation?
Agatha left the study. She had a lunch meeting with her biographer, Ryan Cabrera. Stevie was with her, but he didn't say anything to me until Agatha was out of earshot.
What did Mr. Rogers say to you?
He looked at me and said, "Don't count your millions yet."
After Mr. Rogers told you not to count your millions yet, did you see him again?
Yes, that afternoon, when I had dropped off dinner for Agatha and Stevie around 6 p.m. Up in their study. After that, I just cleaned up dinner and went to bed. So that was the last time I saw either of them that day.
Okay, Mr. Mars, let's shift to the next day then, August 15th. How did that morning begin for you?
It started like usual. I woke up and started making coffee for Agatha. When I went to take it to her, though, she wasn't awake.
What did you see?
I saw Agatha lying in her bed. She wasn't moving.
Did you say anything?
I don't know. I tried to, but I mean, she wasn't responding. She didn't respond. I thought, I mean, I mean, Agatha was dead.
What did you do?
I couldn't think. I couldn't breathe. I just stumbled my way over to Stevie's room to tell him, and then I just fell to the floor and stayed there until some officers arrived.
Mr. Mars, you've been here throughout the course of today's trial. You heard opening statements, Mr. Rogers testify, Ms. Bond. We've heard a lot about a drug called chlorandramine. You ever bought that drug?
No, never.
Have you ever put chlorandramine in Agatha Lee's pill organizer?
No, she's allergic to that drug. I would never do that.
Did you put chlorandramine in your closet on August 14th?
No, I never even bought it. I don't know how that got there.
You said you didn't even buy it. Mr. Mars, do you know if chlorandramine is easy to purchase?
I mean, it's sold over the counter. You can buy it at most pharmacies.
On August 14th, did you ever leave Miss Lee's mansion?
Yes, for lunch with Agatha.
When you had left with Agatha Lee, was Stevie Rogers still inside the home?
Yes. I mean, when we both left, Stevie, he stayed home.
To your knowledge, Mr. Mars, did anyone else have access to Miss Lee's mansion on August 14th?
The only people that I know that had keys to the mansion were those of us that lived there. So that would be myself, Agatha, and Stevie.
Thank you, Mr. Mars. No further questions at this time, Your Honor.
Cross-examination?
Yes, whenever you're ready.
Mr. Mars, I've just got a few questions for you, okay?
Of course.
Now I want to pick up right where you left off. Chlorandramine. Now you managed Miss Lee's medication before she died, right?
Yes, all of her medication and vitamins.
So you knew she took an arthritis medication?
Yes, Winterin. She took 2 pills every day.
And you also knew she had a deadly allergy to chlorandramine?
Yes, of course.
Now, before Miss Lee died, you knew that chlorandramine looked just like Miss Lee's daily meds.
The Winterin, specifically, yes.
They had the same shape?
Yes, they're both these small purple pills.
Right, so it had the same size.
Yes.
Same color?
Yes, like I said.
And a week after Miss Lee died, the police entered your room with a warrant.
Yes, they did.
They searched your closet.
Yes, I believe it was just the detective and that private investigator that Stevie hired.
So bringing it back to my question, the police, they searched your closet.
Yes.
A closet which you used every single day.
Yes, it was my closet.
Ms. Hill, if you could please pull up Exhibit 15. And in your room, in your closet, which you used every single day, Mr. Mars, they found this bag.
Yes, they did, sitting on top of a bunch of blankets.
Now, you claim you've never seen this bag in your life, right?
Never, not until the detective showed it to me.
But you also know that your fingerprint was found on this bag.
Yes, on the zipper.
And in this bag, which you had in your closet, which you used every single day, which had your fingerprint on it, they found a drug.
Yes, a drug and some cigarettes.
And that drug was chlorandramine.
Yes, like the private investigator talked about before, there was the bottle of pills.
Now I want to talk about when you might have gotten these pills. Mr. Mars, you remember you've been in court throughout today's proceedings, right?
Yes, although I want to say I never bought those pills, just to be clear with you.
Okay, Mr. Mars. And you remember that Mr. Rogers spoke about a conversation that he had with his grandmother.
Yes, that morning in the study.
And you also remember a conversation happening.
Yes, I remember it differently than Stevie, apparently.
Right, you remember it differently. But either way, after that conversation, you went to a pharmacy.
I took Agatha Lee to lunch, and then, yes, I did go to a pharmacy.
So that's a yes to my question. After that conversation, you went to a pharmacy.
Yes, while Agatha was at lunch.
Okay, Mr. Mars. And finally, I just want to ask you, to the best of your knowledge, do you know if chlorandramine has ever been in Miss Lee's house other than what they found in your room?
I mean, it had to have been there on the 14th when she died. But no, not that I know of. Like I said, I've never had it.
And aside from you, were you aware of anybody else that knew of the similarities between Miss Lee's arthritis medication and chlorandramine, that deadly drug?
Well, if Stevie Rogers went and bought it, then yeah, he would have seen the similarities.
Mr. Mars, that wasn't my question. Are you aware, I'm not asking you to guess or speculate as to possibilities, are you aware of anybody else that knew of the similarities between Miss Lee's arthritis medication and chlorandramine, that deadly drug?
Yes.
Who would that be?
Stevie Rogers.
You're definitively aware that Stevie Rogers knew of the similarities between Miss Lee's daily meds and chlorandramine, that deadly drug.
I believe that he gave chlorandramine to her on the night of the 14th. So yes, he would have known.
Mr. Mars, I understand that's what you believe, but I want to talk about what you know. Now, do you know for a fact Mr. Rogers knows about the similarities between that arthritis medication and chlorandramine? And that's a no to my question, right? You don't know that.
For a fact, no.
Objection, Your Honor. Speculation may be heard.
Go ahead.
Although opposing counsel is phrasing his question as to what Mr. Mars knows, he's asking if Mr. Mars knows what Stevie Rogers knows, and that connection is speculative. Mr. Mars can testify as to what he believes, as to what he's seen, but to be asked if he knows what another person knows in their head is speculative.
Response, Your Honor?
Yes.
It's actually quite the opposite. Mr. Mars is testifying, or did try to testify, to what he suspected he knew Mr. Rogers knew. He said, I know Mr. Rogers knows this. I'm actually just trying to clarify that the witness is speculating. He doesn't know that for a fact.
Yeah, objections overruled. I agree with plaintiff's counsel here. Continue.
Yes, Your Honor. So, Mr. Mars, just to be clear, you don't know for a fact that Mr. Rogers knew about the similarities between that arthritis medication and chlorandramine.
For a fact, no.
And finally, Mr. Mars, aside from you, were you aware of anybody else that would inherit millions of dollars if Miss Lee died?
I mean, as far as I know, I was who she put in the will, if that's what you mean.
That's exactly what I mean. You would be the only person to inherit millions of dollars if Miss Lee died, right?
Yes, she named me in her will.
Thank you, Mr. Mars. No further questions.
Redirect examination, Your Honor.
Go ahead.
Mr. Mars, you were just shown a photo of a black bag. It's a black bag that we've seen a lot today. Do you remember hearing Ms. Bond testify?
I do, yes.
Do you remember when she said she found that bag in your room?
That was August 21st, the second time that she had gone to my room.
When was the first time that she went to your room?
On August 15th.
Did you see that bag in your room on August 15th?
No.
Did you see that bag in your closet on August 15th?
No, I didn't.
Did you see that bag at any point up until Ms. Bond showed it to you?
No, I had never seen that bag before.
Thank you, Mr. Mars. No further questions, Your Honor. Barring any recross,
No recross, Your Honor.
we'd ask Mr. Mars be allowed to step down.
Mr. Mars is excused. Thank you for your testimony today.
Thank you.
Does the defense have another witness to call?
Yes, Your Honor. Defense calls Ryan Cabrera.
Good afternoon, Ms. Cabrera. You are presumed to have been sworn in.
Good afternoon.
Whenever you're ready.
Please introduce yourself.
Hi, I'm Ryan Cabrera.
Miss Cabrera, what do you do for a living?
I'm a writer. I wanted to be a news reporter, but after my 300th letter to the New York Times, they told me to stop asking. So I became a biographer.
Miss Cabrera, can you tell us how you got involved in today's case?
Sure. Drew called me and asked me to testify for him.
You mentioned that Drew called you. How do you know Drew?
I was writing a biography for Miss Lee. Drew was usually in the background, erasing his Sudoku answers.
You mentioned a Miss Lee. Can you tell us who that is?
Agatha Lee is only the best writer of our generation. Think J.K. Rowling, but less controversial.
Miss Cabrera, you also mentioned a biography you were working on for her. Can you tell us how you got that job?
To tell you the truth, I kind of hit rock bottom. I ended up having to write a biography for the Taco Bell Chihuahua. That's something I'm not proud of. I wanted to restart my career, so I wrote a letter to Agatha asking if I could write about her.
So when was the first time you met Miss Lee?
That was in February of 2018 at her house.
How often did you work with her before she passed away?
We'd meet a couple times a week for interviews for about 6 months.
What would you two talk about during those meetings?
Typical interview topics. She'd tell me about her childhood, how she grew up, what it was like to be the Agatha Lee.
And you said earlier that you first met Miss Lee at her house. Would you usually meet there with her?
We'd usually meet there. Sometimes we'd meet at local restaurants that Agatha liked.
Miss Cabrera, are you aware of anybody else who was living at Lee Manor during the time you were working with Miss Lee?
Yes, I believe Drew was living there as her healthcare taker.
Did you ever get a chance to see the two of them interact?
Yeah, Drew was usually around when I'd come to see Agatha.
Miss Cabrera, how would you describe those interactions?
They seemed like grandma and grandson, always laughing, smiling. Seemed like they got along.
Did Miss Lee ever say anything to you about Drew Mars?
She did. All she told me was one day that she was going to leave everything to Drew.
Miss Cabrera, I want to turn your attention now to the plaintiff, Stevie Rogers. During your time with Miss Lee, did she ever mention him?
She did, a few times.
And when was the last time Miss Lee talked about the plaintiff?
That was the day before Agatha died. We met at Stupendous Steaks, one of her favorite restaurants, but she seemed different.
Miss Cabrera, you said Miss Lee seemed different. What do you mean?
She was less talkative, seemed like she had less energy. She said something about having a conversation with Stevie and hoped she'd be forgiven for something.
Objection, Your Honor, to hearsay to the statements of Miss Lee to Miss Cabrera.
Response, Mr. Curdy.
Yes, Your Honor. To the first half of the statement that Miss Lee said she had a conversation, that testimony has already been put on the record through both the plaintiff and Drew Mars. Nobody here disputes that on August 14th, Miss Lee and the plaintiff had a conversation. To the second half, that Miss Lee hoped she'd be forgiven for whatever happened then, the defense argues under 8033 that that is an exception to hearsay as it's a then existing emotional condition, specifically that Miss Lee is expressing some level of angst or regret.
Your Honor, if I may respond.
Yes, please do.
The statement, I hope that I'll be forgiven for something, is being used to transmit that there's something for Stevie to need to forgive Miss Lee for. As defense counsel acknowledged in their opening statement, the contents of that conversation on the morning of August 14th are in dispute. It's the plaintiff's contention that Miss Lee told Stevie that she'd be leaving everything to him. And defense counsel is arguing that actually in that conversation, she said she wouldn't be leaving everything to Stevie. And so they're not using the statement, I hope, for any hope that Miss Lee had, but rather to transmit that there was something for Stevie to be forgiven about. So it's not about hope, but the rest of the statement. And so it doesn't fall under Rule 8033, which is a then existing, a state of mind, motive, intent, or plan. Hope doesn't fall within that scope.
Response, Your Honor.
Go ahead.
Specifically, Rule 8033 is for a then existing emotional, mental, or physical condition. We're not saying this falls under the mental aspect for motive, intent, or plan, as Ms. Hill would point out. We're saying it falls under the emotional aspect. And the hope part of that statement goes in conjunction with that. You can't just splice the statement in half and then say the rest of it doesn't apply. This witness has already testified that Ms. Lee had a different demeanor that day. She was less talkative. She looked, quote, different. That lays the foundation that Ms. Lee, when she said, I hoped I'd be forgiven for it, she was expressing some level of angst or regret, and thus 8033 would apply.
What is your one second, Ms. Hill. What is your response, Mr. Curdy, to that latter part of the sentence that in Ms. Hill's argument, she said that there is some underlying truth being asserted in that statement? What's your response to that?
Well, yes, Your Honor. As a defense, we are arguing an exception to the hearsay rule. In other words, we're saying that we are using it for the truth asserted within that statement. We're not saying we're not using it for that truth.
And then, Your Honor, I'd amend my objection to hearsay within hearsay. If they are offering the latter portion of that statement, I hope she'll forgive me, that relies on underlying hearsay, what Miss Lee said to Stevie in that conversation, that she wouldn't be putting the will back in his name. And so it's hearsay within hearsay. If Your Honor is convinced that I hope does fall under the exception to Rule 8033, then there's still the problem of the second hearsay level, what was said in the conversation with Stevie.
Response, Your Honor.
Sure, this is the last word.
Yes, Your Honor. No statement from the plaintiff has been elicited here for hearsay within hearsay to apply. But even if the court does believe that argument does fit here, Ms. Hill has basically agreed that 8033 applies to Ms. Lee's statements, and party opponent would apply to any statement offered to Ms. Lee on the behalf of the plaintiff.
Okay, overruled on hearsay within hearsay, sustained on 8033.
Yes, Your Honor, motion to strike anything that's on the record from that statement.
Yes, it will be stricken.
Yes, Your Honor.
May I proceed?
Go ahead.
Ms. Cabrera, did you ever see Ms. Lee after lunch that day?
No, that was the last time I saw her.
I want to turn your attention to August 15th, 2018, the next day. Did you ever hear from Drew Mars?
Yes, Drew called me around noon. He was sobbing. I could barely understand him, but he said Agatha was gone.
Ms. Cabrera, you mentioned at the beginning of your direct examination that Ms. Lee was a famous writer. Are you familiar with the plot of her book, Death in a Bottle?
I sure am.
Can you tell us what happens in that story?
Yes, at the beginning of the story, this airplane tycoon dies. Everybody thinks it's natural causes until the toxicology report reveals chlorandramine poisoning. And the whole time, everyone thinks it's the caretaker. But there's a big twist at the end.
Miss Cabrera, can you tell us what that twist is?
Well, spoiler alert, but it wasn't the caretaker. It was the grandson.
Ms. Cabrera, are you familiar with Exhibit 6, the police report done in this investigation?
Yes.
If I were to show that to you, would you be able to recognize it?
I would.
Your Honor, showing Exhibit 6 to the witness, it's been pre-admitted. Is this that police report, Ms. Cabrera?
Yes, appears to be.
Can you read line 25 for us?
Yes, that line says, we searched Roger's bedroom. We found a copy of Death in a Bottle next to the bed, dog-eared about 10 pages before the end. No evidence was collected from Roger's bedroom.
Does this report mention anywhere that another copy of that book was found?
No, it doesn't.
I have one more question for you, Ms. Cabrera. Are there any similarities between that book and today's case?
Yes. You have the dead person at the very beginning of the story. You have everybody thinking it's the caretaker the whole time. And of course, you have the chlorandramine.
No further questions at this time, Your Honor.
Cross-examination?
Yes, go ahead, Ms. Hill.
May I proceed?
Yes.
Ms. Cabrera, I'm looking for a number. How many copies of Death in a Bottle have been sold to date?
Upwards of 65 million.
Objection, Your Honor. Relevance. May I be heard?
Sure.
Your Honor, how many copies of this book there are in the world makes no fact in this case more or less probable, specifically whether or not, for the defense's theory or the plaintiff's theory, who killed Miss Lee. All that matters is that there was one book in this case, and that one book was found in the plaintiff's possession.
Response, Your Honor?
No, Mr. Curdy, I agree with you, but we've opened the door sufficiently to talking about the copies and the number of copies of that book in this trial already. Ms. Hill, if you could just limit that line of questioning so it doesn't become redundant at this point.
Yes, Your Honor.
Overruled.
So there are 65 million copies of Death in a Bottle circulating worldwide.
Yes, even I have one.
The book's been translated into 100 languages.
I think so, yeah.
It was, in your words, an instant hit.
Yes, her voice just demonstrated such depth and emotion.
Ms. Cabrera, you know a little bit about publishing yourself.
I'd like to think so, yes.
You've got 8 best-selling biographies.
That's right.
You published your own autobiography.
I sure did.
So with Death in a Bottle so successful, you were stunned that Miss Lee never published again.
Absolutely, I thought it was a shame.
But you learned that while she never published again, she wrote plenty more books.
Objection, Your Honor. The opposing counsel is using hearsay to form this question. May I be heard?
Yes, please explain.
Make an offer of proof, Your Honor.
Yes.
Your Honor, opposing counsel is referencing a statement provided to this witness by Miss Lee during their meeting at the Stupendous Steaks restaurant August 14th, wherein Miss Lee said, "I have other unpublished novels in my study." Opposing counsel is going to use that statement to prove the truth of the matter asserted within that statement, that Ms. Cabrera does want novels that are in existence.
A response, Your Honor?
Okay, so your argument is that this question is dependent on hearsay.
Yes, Your Honor.
Okay, respond.
Yes, Your Honor. Firstly, in the contents of the will, we learn that Miss Lee leaves to Drew Mars, or whoever inherits it, the books that are in her study, which are those unpublished works in question. But more importantly, Your Honor, we're not offering these statements for their truth, that Miss Lee did in fact write other novels that have yet to be published, but rather for their effect on Miss Cabrera. If I can make an offer of proof, Your Honor?
Go ahead.
We have it on a good faith basis that this witness has been offered all of those unpublished works by the defendant. And so it's relevant for the jury to understand that Ms. Cabrera knows about these unpublished works, that she learned about them from Agatha Lee, even though we're not offering them for their truth, that those books actually exist, because it's our contention that the offer to have those books has biased Ms. Cabrera's testimony, and that bias is always relevant.
Response, Your Honor.
No, the objection is overruled.
So Ms. Cabrera, you learned that there were unpublished works that belonged to Miss Lee.
Yes, at our last meeting, Agatha dropped the bomb on me that she'd written a lot of different books and left the unpublished copies in her study.
Right, every time you interviewed her in her study, there were a dozen unpublished works just sitting behind you.
Yeah, that's right.
And you were floored at this news.
Absolutely.
Because God knows how much those books are worth.
Yes, and God knows how much I wanted to read them.
Right. So, Ms. Cabrera, you understand that the will reading was on August 20th of 2018.
Yes.
And that's when you saw those unpublished works for yourself the first time.
That's right.
But today it's August 2020.
That's the date.
And the question of who will get those books, well, it's unanswered, right, Ms. Cabrera?
I guess that's why we're all here.
Right, it could be Drew Mars.
Yes.
Or it could be Stevie Rogers.
I suppose so.
But ma'am, you want it to be Drew Mars, right?
Well, I want it to be Drew Mars because I know that Drew didn't do this.
You want it to be Drew Mars because that means you'll get those books. right?
No, I'm testifying here because I don't think Drew murdered Agatha Lee.
Well, let's break that down a little bit. In June of 2020, you got a call from Drew Mars,
Yes.
and she asked you to testify in today's trial.
He asked me to testify, and I said yes.
He asked you to testify on his behalf.
Yes,
You said absolutely.
I sure did.
And then he said, good. On an unrelated note, is there anything from Agatha's estate that you might be interested in?
That's how it went.
You said absolutely.
Yeah, I said I'd like those books.
Right. And well, Mr. Mars, he told you what you needed to do to get them.
I'm not sure what you mean.
Well, he said, so long as I am still in possession of Agatha's estate at the end of this trial that we're hearing today, those books are yours.
That's what he said, but I'm not testifying to get any books. I already told Drew I would testify before he said I could have them.
I understand that's what you're saying here today in court, but in your own words, you're not worried about those books.
No.
Because you're here testifying on Mr. Mars's behalf.
Yes, I know that Drew didn't kill Agatha Lee, so I'm not worried about it.
Well, now that we know why you're here in court testifying, I want to talk about what you can and what you can't tell us. Now, on August 14th, you were with Agatha Lee.
Well, I was, but I'm not testifying because of those books.
Ma'am, on August 14th, you were with Agatha Lee.
I was.
You went to her lunch with her.
Yes.
Around midday.
Around noon, yeah.
You're familiar with the police report, so you understand that Miss Lee didn't die until that evening.
Yes.
In her home.
That's where she was found.
Ma'am, you were never in Lee Manor on August 14th.
I wasn't.
So if a witness took that stand and said that they saw the defendant going from one room to Agatha's at 9:40 p.m., well, you couldn't tell us any different.
If that's actually what happened, yeah.
You couldn't tell us any different because you weren't there.
I wasn't.
But you can tell us that Miss Lee had a plan on the 14th.
A plan?
A plan to call her lawyers?
Oh, yes. Agatha did say something about wanting to call the lawyer.
Oh, right. She said she wanted to call her lawyer Kirby Doolittle, right?
Objection, Your Honor. Hearsay.
Response, Your Honor?
Yes.
Specifically, the statement was that she was going to call her lawyer Kirby Doolittle. That's clearly a statement of a then existing intent or plan and is an exception to the rule against hearsay under Rule 8033.
Response, Your Honor.
Yes.
We would argue that saying I was going to do something is not an intent or plan anymore. Saying I am going to call my lawyer or I plan to call my lawyer would fall within that exception. But saying it was something you thought about doing before doesn't meet the criteria of 8033.
Response, Your Honor?
Sure.
I said I was going to call my lawyer when I asked the witness the question because I was speaking about a conversation that occurred in the past. But the statement that was related to the witness, as the witness testified, was I am going to call my lawyers a future intent.
Okay. Would you like to adjust your response, Mr. McCurdy?
But Your Honor, if that's what Ms. Hill said, the audio was cutting out, then yes. But if it's not, we would stand by our initial response.
Okay. So if the statement in question is I am going to call, then the objection is overruled.
Yes, Your Honor. And so to be clear, Ms. Cabrera, Ms. Lee had a plan to call her lawyers on August 14th, right?
Yes.
She wanted to see Kirby Doolittle on Friday.
That's what she said.
Thank you, Your Honor. Nothing further for the witness.
No redirect, Your Honor. May this witness be excused.
She may. Thank you, Ms. Cabrera, for your testimony today. Does the defense have any further witnesses?
Defense rests.
Okay. So we will now hear closing arguments from each party and forego any other breaks. Everyone should please switch back to speaker view at this point. Whenever the plaintiff is ready, please begin with your closing argument.
Yes, Your Honor, just one moment of the court's indulgence.
Of course.
May I proceed?
Yes.
May it please the court, opposing counsel, members of the jury. Without those pills, the defendant was going to lose the will. Members of the jury, at the beginning of today's trial, the defense said something, and I thought it was interesting, so I wrote it down. They said it wasn't a coincidence, but a setup. And I can't agree more. It wasn't a coincidence. It's no coincidence that just a day after Agatha Lee promises Stevie Rogers that she's going to change her will, include him in it, bring him back into the fold, Agatha Lee's found dead. Because this case, well, it doesn't begin on August 14th of 2018, like the defense might have you believe. No, it starts in February of 2018, excuse me. See, because in February of 2018, Miss Mars learns that she's going to receive Agatha's estate. In February of 2018, Mr. Mars gets life-changing news. So on August 14th, when Mr. Mars overhears a conversation between Agatha Lee and Stevie Rogers, well, he knows he needs those pills because without them, he's going to lose the will. So what does he do? He drops Agatha at her lunch meeting. He goes to the pharmacy, purchases chloroandramine, a drug he knows Agatha is fatally allergic to. Swaps out the pills in her pill case, and then he waits. See, members of the jury, that's why we're here today in trial. That's why we, as the plaintiff, are suing Mr. Mars. Because here in Midlands, there's something called the Slayer statute. If you're written into someone's will, and then you cause their death, you can't inherit their estate. That's exactly what happened here. So, members of the jury, this is a civil case. And that means that we've got a particular burden as the plaintiff. See, we didn't have to prove anything to you beyond a reasonable doubt. This isn't about innocence and guilt, it's about liability. We have to prove to you that Mr. Mars caused Agatha Lee's death knowingly or purposefully, and we have to do that by a preponderance of the evidence. So let's be very clear about exactly what that means. A person acts purposefully when they do something hoping for a particular result, and they act knowingly when they do something that they know will cause a particular result. See, Mr. Mars, well, he did both. He acted knowingly when he used that information about chloroandramine to go to the pharmacy and find a drug that he knew would kill Agatha, and he acted purposefully when he switched out those pills, waiting for her to die so he could inherit the will as is. We prove that to a preponderance of the evidence. That's a hair over 50%, a tip of the scales. So, like the judge just told you a moment ago, the question you have to answer is simple. Is it more likely than not that the defendant purposefully or knowingly caused Ms. Lee's death? And that question, well, I think it becomes pretty easy to answer if you return to just those three questions that Mr. Guillaume asked you at the beginning of today's trial. 1, who knew that Ms. Lee's daily medication looked identical to chloroandramine before she died? 2, in whose room did the police find chloroandramine? And 3, who stood to inherit $20 million if Ms. Lee died before she could change her will? The answers to those questions, the defendant, the defendant, the defendant. See, members of the jury, it's no coincidence that the answer to all three of those questions is the same person. It's no coincidence that that person is the defendant. But I want to make sure that's clear. So I want to walk you through the evidence piece by piece, witness by witness. And at the beginning of trial, the defense told you that that conversation on August 14th was in dispute, and they're right. But I want to be clear about what they're asking you to believe. See, Mr. Rogers took that stand. He told you that he had a conversation with his grandmother. She said that she was happy they'd reconnected, happy he was back in her life, that he wanted to write her back into the will. But you don't have to take Mr. Rogers at his word, because you'll remember that at the end of that conversation, he said that his grandmother was going to call her lawyers. The defense's own witness, who stands to gain millions of dollars in royalties from unpublished novels by a best-selling author, told you herself. Agatha had a plan, call her lawyers on Friday. Well, who else might have known about that plan? The defendant. It was the defendant that was standing just outside of the room when Agatha told that to Stevie. So what about those pills? See, the defense is making a big deal about the sole copy of this book, Death in a Bottle, found in Mr. Rogers' room. And sure, that's the only book found in the house. But I want to talk about what else was found in Lee Manor on August 15th, 2018. Excuse me, August 20th. Because yes, there was the book. There was also a case with chloroandramine pills inside. Guess where that case was found? In the defendant's closet. But what's more, there was one fingerprint on that case, and it belonged to the defendant. See, members of the jury, it's not a coincidence, but it's not a setup either. When the evidence starts piling up and up and up like this, it's not just 50%, it's not a hair over 50%, it's clear. Without those pills, the defendant was going to lose the will, and he knew it. Because when the defense asks you to compare the plaintiff and the defendant to figure out who you think killed Agatha Lee, I want you to ask yourself, who went to a pharmacy on August 14th, doesn't remember what they purchased and didn't get a receipt? Who knew for years that Agatha was allergic to chloroandramine, and in whose closet was chloroandramine found? It's clear, members of the jury, it wasn't a coincidence, it was the defendant. Find him liable.
Mr. Curdy, are you ready?
Your Honor, before we begin, is it possible for our bailiff to come on screen? We believe that we have 8 minutes till all loss, which would impact both closing and rebuttal. Is that correct?
Well, let's go ahead and finish under normal time. It looks to me like we're doing okay, and I think there's going to be some flexibility given the setting. Thanks for checking in on that.
Great. Glad we handled that before.
How much time is allotted for closings for your co-counsel?
We've got 8.5 minutes, and then whatever was just remaining from before. So probably around 11 to 12.
That shouldn't be a problem. Yeah,
okay.
Thank
you.
No problem.
So there we go.
I'll do my best to keep it brief, Your Honor. May I go ahead and proceed?
Go ahead.
Members of the jury, you see, it wasn't a coincidence what happened on August 14th and 15th. It's not a coincidence what's happening today, because it's all a setup. And I want to start by telling you what Ms. Hill didn't tell you. I want to start by telling you what exactly it is the plaintiff had to prove in this case today. Because you see, they have the burden of proof here. We don't. And these are the elements they had to prove to you. First, they had to show that Drew Mars took some action to cause Miss Lee's death. Specifically, they had to tell you or prove to you that Drew Mars switched Miss Lee's medication with those chloroandramine pills. And then they had to show you that Drew Mars did that purposefully or knowingly. And they got to show that to you to be more likely than not. But when you think about what testimony they elicited from their two witnesses, you find yourself wondering, was it proven? And the reason Ms. Hill didn't tell you is because she knows she didn't meet their burden. It's because she knows this was a coincidence, or it was not a coincidence, that it was a setup. Did you hear anybody say they saw Drew Mars with chloroandramine on August 14th before Miss Lee passed away? Did you hear anybody say they saw Drew Mars with chloroandramine on August 15th? or 16th or 17th or 18th, 19th? No. But they like to tell you, well, we found those pills in Drew Mars's closet 6 days later after our hired private investigator searched his room unsupervised. There's no proof here. Was it proven? No. And when you look at that second element, ladies and gentlemen, it presupposes that that first one was proven, because you can't take action purposefully or knowingly if you didn't take action at all. They didn't prove it. And I can stop right now. I can sit down, because at this point, the law would require you to find Drew Mars not liable, simply because the plaintiff failed to meet their burden. But we didn't stop there. We presented our own evidence, because it wasn't a coincidence. It was a setup. You heard in testimony today that the plaintiff did, in fact, know about Miss Lee's chlorandramine allergy. She said so herself. You heard today that the plaintiff had access to Miss Lee's pills on August 14th, through our witnesses, through their witnesses. You heard today that the plaintiff had access to Drew Mars's room, through our witnesses and their witnesses. You heard today that the plaintiff had access to Miss Lee's room, through our witnesses and their witnesses. But you also heard that as much as the plaintiff likes to tell you where Drew Mars was, what Drew Mars was doing on August 14th, that the plaintiff was alone, all by herself on August 14th. Now, we don't know if during that time she went into Miss Lee's room and switched those pills, because she had just been told in the morning that she wasn't going to be put back in the will. We don't know if during that time she went and purchased chlorandramine, because she told you herself, or he told you himself, I know how to get access to that drug. We brought to you some more evidence. You heard about motive in this case, but you heard Drew Mars say that on that conversation in the study on August 14th, he heard Miss Lee say, I'm not going to put you back in the will, Stevie. But you also heard that the one with the real motive here was the plaintiff, who had a $2 million trust fund that plummeted to just $2,000 when she decided to show up. And you also heard about the Slayer statute. And that's important, because the plaintiff knew, if I can't convince Nana Lee to rewrite her will, to put me back in it, get Drew Mars out, why, I'm just going to go in there and I'm going to take that estate from her. She killed her, because this wasn't a coincidence. It was a setup. And if the plaintiff wins this case, she gets what she's been after the whole time, the Slayer, or the estate. But you also heard about death in a bottle, the one copy of the book in this case. And you heard about similarities. The millionaire in that case died as a result of chlorandramine. That's what happened here. In that case, the caretaker is accused. That's what's happening here. But in that book, the grandchild killed the millionaire. And that's what happened here. And the one copy of that book was found in the plaintiff's room, because it wasn't a coincidence. It was a setup. But we also brought to you our own timeline, because we wanted to show you the other half of the picture, what the plaintiff wants you to ignore. And that's what the plaintiff was doing that entire week. Miss Bianchi, if you could. Because you see, on August 14th, there was a conversation in the will where Miss Lee tells the plaintiff, I'm not putting you back in. On the 15th, Miss Lee is found dead in her room, and the plaintiff comes to a huge conclusion that suddenly Miss Lee had been murdered. But I want you to focus on August 20th and 21st. Because you see there that on the 20th, the plaintiff filed this lawsuit where they're alleging specifically that Drew Mars killed Agatha Lee with chlorandramine. But on the 21st, we get the autopsy result back. And it's then, for the first time, that anybody knows chlorandramine was in Miss Lee's system. You see, members of the jury, the plaintiff knew what had happened to Miss Lee before anybody else did. That's not a coincidence. It is a setup. There's no other reason for the plaintiff to know what exactly killed Miss Lee other than the fact that they killed Miss Lee themselves. It wasn't a coincidence. It was a setup. Miss Hill likes to tell you that Drew Mars had the pills because he didn't want to get taken out of the will. Members of the jury, the only person who had the pills in this case was the plaintiff. The person who wanted the estate the most was the plaintiff. Because it's not a coincidence, it was a setup. Find Drew Mars not liable. Thank you.
Your Honor, with all loss, do I have time for rebuttal? I believe I have 1 minute and 40 seconds left.
I think the bailiff said it was okay, but let me check again. Are we
Yeah.
good?
You can go ahead and proceed.
Great,
Okay.
thank you. Ms. Shapiro, would you mind? May I proceed, Your Honor?
Yes.
Just a moment ago, the defense stood up here and they asked who had chloroandramine on August 14th. So I want to be clear about what's different between the plaintiff and the defendant. Who went to a pharmacy on August 14th and couldn't provide a receipt? If you remember from today's trial, well, the answer to that question isn't Mr. Stevie Rogers. It's Mr. Drew Mars. So then I want to think about something else. Who was seen creeping toward Miss Lee's room, holding something on August 14th? Was it Stevie Rogers? No. It was the defendant, Drew Mars. So then I want to ask another question. In whose possession was chloroandramine found? Was it the closet of Stevie Rogers? No. It was that of the defendant, Mr. Drew Mars. And then lastly, whose fingerprint was found on the chloroandramine case? Again, the answer to that question is not the plaintiff, it's the defendant. Members of the jury, it wasn't a coincidence, it's not a setup. Because without those pills, the defendant was going to lose the will. Find him liable.
Okay. So judges, at this point, now that closing arguments are done, please complete and submit your ballots. Everyone should stay on until everyone has submitted their ballots, please, and then we'll do brief comments for the competitors.
Perfect. I'm going to go ahead and stop the